As we enter into this section, there's going to be a couple of things that are important for you to pay close attention to. One is, please notice the top of the slide over the next couple of slides. For example, this one is agent's responsibility to principal. In a subsequent slide, you're going to see that I reversed that. But right now, as an agent, what are you going to be responsible to in regards to your principal? So what this basically means is, if you do something wrong, what's going to happen to you? Well, let's look at number one. If in fact you have harmed your client, if you have broken a rule, you can be disciplined by the real estate commission. But let me turn this into a test question for you real quickly. A lot of agents are concerned about what we call the brown letter from the real estate commission. It's the disciplinary letter. It's actually called a letter of inquiry to find out whether you've done anything wrong. But a lot of agents are really concerned about this. But here's one thing I always tell them. The real estate commission can never fine, F-I-N-E, the real estate commission can never fine you for acts that you do under your real estate license. So agents say, well, what's the big deal? Hey, look, I didn't say you could never be fined. I said it would not be the real estate commission that would fine you. All the real estate commission can ever do to you is reprimand you, censure, C-E-N-S-U-R-E, which is basically a public castigation. So reprimand or censure, but they could also suspend or revoke your license. And if you make money by virtue of your license, it is a big deal for your license to be suspended or revoked. So let me remind you what the important point there is. I don't care how pretty they write it in the question. The real estate commission will never fine you for acts that you do on your license. Now look at the second bullet point. Now you might be fined. You may end up having to pay damages in a court case, because if you harm your principal can certainly sue you and you would be subject to damages that way. And then finally, if what you did was a criminal violation, then obviously you could be prosecuted for that as well and disciplined for that. But it would not be the real estate commission doing it to you. It would be the court system. So let me give you the inverse of what I said just a moment ago. The real estate commission can never fine you. The courts can certainly fine you. The courts, however, cannot take your real estate license. The courts didn't give you your real estate license, so they can't take it away. Only the commission can do that. If you haven't seen it yet, start picturing what those questions would look like in your mind. First of all, what was the penalty? What's the disciplinary action, and who's doing it? Is it the real estate commission? Is it the courts, et cetera, et cetera? That is going to be a critical part of you reading the question. Now, notice at the top of this slide, duties and liabilities of principal. So now we're finally talking about the client. We've been talking about the liabilities of agents for a while now. So now let's talk about what the principals have to do. Well, for you, the agent, here's what they owe you. They owe you to act in good faith. Your principal should act in good faith. Here's what that means. If I have a house listed, then the principal, the client, the seller, should make that house available for showing. I'm out there, the agent, spending my money, marketing the property, spending my time and efforts trying to bring people to the front door. If the seller doesn't make the house available for showing purposes, then I can't sell it and make any money. So they would not be acting in good faith. Closely associated with that is they should keep it relatively clean, pick up the dirty dishes, the dirty diapers, et cetera, lock up the cat so that we can show the property, act in good faith. And importantly, your client should compensate you when it is the appropriate time. In a later chapter, we will talk about at what point you earn your compensation versus when you get paid. But whenever you're entitled to that compensation, your client should act in good faith and pay you or allow you to be paid however the arrangement was made. And then notice this. What does your principal owe to third parties? I actually am going to take these bullet points in reverse. I want to talk about number 2 first. Your client, let's say a seller, the seller owes a buyer nothing in North Carolina, okay? North Carolina is what we call a caveat emptor state. Caveat emptor means let the buyer beware. That means that the buyers are responsible for their own inspections, okay? So technically your seller doesn't owe the buyer anything. Now here's what I do tell my sellers when I talk to them. The only way, seller, that you can get in trouble in North Carolina is if you lie or if you conceal a material fact. If you lie, if you just flat out and say, hey, my house is attached to the public sewer system when it's actually on a septic tank that's broken down. That's a lie, okay? That's fraud. And of course, you can be prosecuted for that. Technically, your client can be prosecuted for that. And then, of course, if you were to conceal a material fact, so for example, if your seller knows that there's a roof leak, they don't fix the roof leak. What they do is they go and paint the ceiling and they put some kilts over it so you can't see where it was. That's concealing a material fact. So sellers, let's talk about this. Either fix your house or let's fix it and disclose it. But what we're not going to do is lie to people about it, nor are we going to try to cover things up. That's the quickest way to get you into some type of fraud or misrepresentation case. And then finally, duties and liabilities of principal, they could be subject to civil liability if they lie. And if the fraud is deep enough, then they could be entitled, or they could have criminal prosecution on that as well. And then the final bullet point that comes up on this slide, the Unfair and Deceptive Trade Practices Act. As you read the name of this act, the Unfair and Deceptive Trade Practices, recognize that this applies to trade practitioners. This is not so much your client as it is the agent, but it actually applies to all trade practitioners. It will apply to attorneys, insurance companies, et cetera, et cetera. Okay. And what this law says is, look, if you violate all those duties that we've talked about, if you lie, cheat, conceal, do those type things, you could be subject to treble damages. Treble damages, literally 3 times the actual damages that you caused. It's not going to be the commission doing it. It's going to be the court system doing it under the Unfair and Deceptive Trade Practices Act. As a trade practitioner, we expect you to act in a certain manner, protect the public. And if you don't do it, they can actually bring you up on charges that can cause you 3 times the actual harm that you caused your client. Okay. So have all those words in mind. I don't think it will be attested at a very, very high level, but Unfair and Deceptive Trade Practices Act, all the stuff we talked about, if you violate those, it's very possible you could also be brought up for treble damages under that. Duties and liabilities of principal and agent. Be very cognizant of not only what the negligent act was, but also who is the disciplinary authority that would act upon that.